discussion. So I'm going to now hand you over to Danielle Gallagher, who's a PhD researcher with us on a Northern Bridge Arts and Humanities Research Council studentship, who will be chairing the first part of the session and introducing Tom. So Danielle, when you're ready.
Thank you, Rory. On behalf of the Transitional Justice Institute and the Ulster University School of Law, I would like to echo Rory's warm welcome to you, Tomoya. We are delighted to have you here to speak with us today on your role as the United Nations Special Rapporteur on Contemporary Forms of Slavery, including its causes and consequences. For those of you who maybe aren't as familiar, Professor Tomoya Obokata is one of the leading scholars on addressing human trafficking and other forms of transnational organised crime from a human rights perspective. And I will just provide a brief introduction to his work for you. He is a Japanese scholar of international law and human rights, specialising in transnational organised crime, human trafficking and modern slavery. He was appointed as the Special Rapporteur in March 2020. In this role, he examines and reports on slavery and slave-like practices around the world by working with relevant governmental, civil society, intergovernmental and other stakeholders. He also currently serves as Professor of International Law and Human Rights at Keele University, a position he took up in 2012. From 2006 to 2012, he taught at Queen's University here in Belfast, and prior to that at Dundee University. He gained his PhD in law from the University of Nottingham and also holds a Master's in Theory and Practice of Human Rights and an LLM in International Criminal Law. Prior to his PhD, Professor Obokata worked for the United Nations High Commissioner for Refugees, Regional Office of Japan and the Republic of Korea. He has extensive experience of working on the issues of transnational crime, human trafficking and modern slavery with relevant stakeholders such as the UK Parliamentary Joint Committee on Human Rights, the Northern Ireland Assembly All-Party Group on Human Trafficking, the United Nations Offices of Drugs and Crime, the International Organisation for Migration and the European Union. Moreover, he has published widely on all of these topics, including with Ulster University's Dr. Brian Payne from the School of Criminology, and previously with our own Professor Rory O'Connell. Having said all that, I know we are all very interested to hear about Professor Obokata's most recent work on the nexus between displacement and contemporary forms of slavery. So it is with great pleasure that I give the floor to him now.
Well, thank you, Danielle, for that very kind introduction. And I thank you to the Transitional Justice Institute for inviting me to this seminar. And it's my pleasure to be able to talk about an important topic of displacement and contemporary forms of slavery today, which was the subject of my thematic report to the UN Human Rights Council back in September. But before going into this topic, I thought I would explain who we are and what we do as the special procedures of the Council, as some of you may not know that. Simply put, we are independent human rights experts appointed by the Council, collectively known as special procedures mandate holders. There are a few titles, such as special rapporteurs, independent experts, and working groups. We typically serve 2 terms to the total of 6 years. So I was appointed in May last year, so I will be serving my tenure until 2026. The special procedures are divided into 2 categories. The first is thematic. As you might have guessed, thematic mandate holders like me address specific topics. In addition to my mandate, the current examples include violence against women, freedom of expression, extreme poverty, human rights of older persons, and business and human rights. As you may be aware, the Council in the last regular session in September has established a new mandate on human rights and climate change, which is to be filled in the next regular session in March next year. My mandate was originally established in 2007 to replace the working group on contemporary forms of slavery, which had been active since 1974. There are two predecessors before myself, so I am the third person to assume this role. Issues I am mandated to address include slavery, servitude, debt bondage, child labor, sexual slavery, and forced marriage. I have also been requested by the Council to work with all relevant stakeholders to promote the implementation of Sustainable Development Goal 8 on decent work and economic growth, particularly Target 8.7, which urges states to eradicate forced labor, human trafficking, and modern slavery by 2030. The second category consists of country-specific special procedures. These mandate holders focus on specific countries but examine a wide variety of human rights issues. The current examples include North Korea, Myanmar, Iran, and Mali. The Council has also established two new mandates in September, which are Afghanistan and Burundi. One of the main tasks common to all special procedures, first of all, is to examine and report on individual themes and country situations on an annual basis. To this end, we submit reports to the Council and the UN General Assembly. As to my mandate, I examined the impact of the COVID-19 pandemic on contemporary forms of slavery last year, as I was appointed in the middle of the pandemic and saw it timely to address this issue. For this year, I dealt with displacement in my report to the Council, as I said in the beginning, and the role of organized criminal groups in contemporary forms of slavery in a report to the General Assembly. In relation to next year's thematic priorities, I intend to focus on protection of minorities, as well as the relationship between informal economy and contemporary forms of slavery. We use a wide variety of information to produce objective and accurate reports. We do our own research, of course, but because of the limited time available, we rely on information submitted by governments, civil society organizations, research institutions, and so on. And sometimes we also hold consultations with relevant stakeholders. The next important task is to conduct fact-finding through field missions. All mandate holders are entitled to visit 2 countries per year. Unfortunately, I have not been able to go anywhere up until now because of the COVID-19 pandemic, but I am due to visit Sri Lanka at the end of this month. In addition, I have received invitations from Canada, Mauritania, and Costa Rica, so I will be quite busy from next year. Another important task is to send communications to governments and other entities when we receive allegations of human rights violations from victims, civil society organizations, and other stakeholders such as international organizations. One advantage of the special procedures is that we can engage with states and other entities much faster than, for example, human rights treaty bodies. The recent examples include communications to the government of China and a number of businesses sent jointly by several mandate holders, such as myself, Special Rapporteur on Minority Issues, and the Working Group on Business and Human Rights, after receiving allegations of forced labor among Uyghur minorities in the Xinjiang province. In addition to encouraging stakeholders to explain and address allegations, these communications facilitate transparency and publicity. Now, having explained the role of special procedures, I now would like to move to the main topic, the displacement and contemporary forms of slavery. I promised to promote a victim-centered approach during my tenure by focusing on particularly vulnerable groups, and I decided to examine the experience of refugees, asylum seekers, stateless persons, and internally displaced persons this year. I shall start by explaining major vulnerabilities or causes which put displaced persons at risk of being victimized in these practices. They become vulnerable as a result of personal, situational, or structural factors. For example, the poverty level among them is known to be very high. As members of populations often marginalized within their own communities and countries, many displaced persons do not have sufficient means of subsistence. Even if they do, their assets are often stolen or taken away, or they need to leave them behind when fleeing home. Discrimination on race, ethnicity, gender, nationality, and other relevant grounds is another root cause of contemporary forms of slavery, including for displaced persons. Structural discrimination may be facilitated by states, employers, or society as a whole, limiting access to decent work, education, and other opportunities. Next, the migration status is another important factor. Those with an irregular or uncertain migration status, including asylum seekers and stateless persons, are particularly vulnerable to contemporary forms of slavery, as many of them do not have a legal right to work or receive social and economic protection and assistance from host countries. They are therefore compelled to accept exploitative work in order to survive in many cases. In addition, informal economy increases the instances of exploitation and abuse. Employment in the informal sector is often characterized by low wages, harsh or abusive working conditions, and a lack of job security and social protection. Also, the bargaining power of displaced persons is often limited because they do not feel empowered to mobilize or unionize. Further, because of a lack of freedom of movement and poor security, displaced persons residing in camps have a high risk of victimization in slavery and other slavery-like practices. This is particularly evident in informal camps and settlements where there are no basic protection and humanitarian structures, including for internally displaced persons. Finally, exposure to criminal groups and traffickers or smugglers is a pressing issue. Displaced persons often have no choice but to rely on them to escape, as regular channels for migrations are very limited or non-existent. The interaction with these individuals and groups may transform into a long-term exploitative relationship, for example, in bonded labor when displaced persons need to pay their fees and debts for migration. In conflict-induced displacements, it has further been found that the parties to the conflicts, such as non-state armed groups and security forces, are overwhelmingly the perpetrators of conflict-related forms of contemporary slavery. So these are some examples of vulnerabilities putting displaced persons at risk of exploitation and abuse. And the next important question is, how are they exploited? In my report, I have identified main manifestations of contemporary forms of slavery affecting them. One example is forced labor. The industries in which displaced persons are regularly exploited include agriculture, construction, catering, cleaning, care services, street vending, and the general service industry. The casualization and informality of the workforce in these industries explain the higher number of displaced persons engaged in those sectors and the greater extent of exploitation. Another example is domestic servitude. This has been identified in all regions of the world. There is a strong gender dimension to this form of exploitation, as mainly women and girls are exploited by domestic servitude. In addition to the harsh working conditions in private homes, it is important to keep in mind that they often suffer from physical and/or sexual abuse at the hands of their employers. In addition, sexual exploitation that may amount to sexual slavery is a serious problem. There have been disturbing reports of displaced women in Nigeria being forced to work in baby factories where they have become sex slaves and bear children without medical assistance. Conflict-related sexual violence has also been used systematically against women and girls in Tigray, Ethiopia, and in other regions, including Latin America. As this year, 2021, marks the International Year for the Elimination of Child Labor as designated by the UN General Assembly, I also decided to examine contemporary forms of slavery affecting displaced children in my report. And in this regard, I have seen clear evidence of displaced children experiencing the worst forms of child labor as defined by the ILO Worst Forms of Child Labor Convention. In Lebanon, 75% of the Syrian refugee children working in the Bekaa Valley are exploited in agriculture. These children are more vulnerable to forced labor because of legal restrictions on access to employment for adults, many of whom are in irregular situations. Risks are even higher for stateless children, as well as others who may not have birth certificates or other identity documents. I have also seen instances of child marriage. It amounts to slavery where control tantamount to possession exists. Child marriage tends to be exacerbated by social and economic insecurity triggered by displacement, particularly in the context of emergency situations such as armed conflicts and disasters. For some Syrian families displaced in Egypt, for example, challenges related to displacement, such as disruption in girls' education, protection gaps, and livelihood uncertainty have forced some girls into marriage, and a similar trend has been observed among the displaced Rohingya communities in Asia. The COVID-19 pandemic has also increased the instances of marriage of displaced girls in some regions of the world, such as Asia and Africa. Many parents view child marriage as a way to cope with economic hardship and to ensure the safety and security of their daughters. Moreover, the forced recruitment of displaced children into criminal groups, including armed and terrorist groups, remains a critical concern. In African countries, including the Democratic Republic of Congo, Mali, Nigeria, and Somalia, many children, including displaced children, are forced to join the ranks of armed groups. The recruitment of adolescents into criminal groups and gangs has also been evidenced in Colombia, Ecuador, and Peru. The limited protection in refugee settlements and camps, coupled with poverty, insecurity, and a lack of access to education and training, leave displaced children in such settings particularly vulnerable to forced recruitment. Now, having explored the key vulnerabilities and manifestations, my report has identified some examples of good practice designed to prevent displaced persons from being victimized in contemporary forms of slavery. As an example, I was encouraged to see that refugees in a number of states globally are given a legal right to work in accordance with the 1951 Refugee Convention. While the primary obligation to provide access to decent work rests on states, I have discovered that many of them work closely with non-state partners to facilitate employment for displaced persons. In this regard, the government of Sweden, in cooperation with trade unions and employers' associations, has introduced a fast-track initiative whereby refugees with qualifications and experience are integrated into the labor market in professions such as medicine, social care, and teaching. The employment opportunities have been extended to displaced persons in the context of the COVID-19 pandemic also. In North and South America and Europe, refugees with medical qualifications have been allowed to join medical personnel to fight the pandemic. Also, displaced populations in some African states such as Cameroon, Kenya, Malawi, Niger, and Zimbabwe, including those residing in camps run by the UNHCR, have been making medical masks. It is also encouraging that the labor and social protection laws and regulations apply to displaced persons equally in various states, thereby enhancing their just and favorable conditions of work. In Japan, employers are prohibited from unilaterally terminating the employment of any workers, including refugees. And those eligible for residence or work permits in Malaysia enjoy the same rights, such as paid annual and sick leave, as Malaysian workers. Syrian refugees in Turkey received cash assistance as part of the Emergency Social Safety Net program, and displaced persons in Uganda have full access to social and health services. Furthermore, education and vocational training for displaced persons are provided in a number of states. Azerbaijan exempt internally displaced persons from payments for education and training, and Germany has been supporting an apprenticeship scheme for asylum seekers, as well as those whose asylum applications have been rejected, but who are not able to return home for various reasons. It is important to emphasize here that such services are often provided by non-governmental entities such as civil society organizations and trade unions. Despite these and other good examples of good practice I was able to identify, there are persisting challenges that must be addressed in order to prevent displaced persons from being subjected to contemporary forms of slavery. For example, effective access by displaced persons to the labor market and decent work is still limited. Of 140 plus states that are parties to the Refugee Convention, nearly half of them have entered declarations or reservations with regard to provisions relating to access to work under Chapter 3, giving them discretion not to grant the same rights and entitlements to refugees like their own nationals. What I have also discovered in this regard is that the vast majority of refugees work in the informal as opposed to the formal economy, even if they have excellent qualifications and work experience prior to displacement. The situation is exacerbated by practical hurdles such as the requirement of work or residence permits, the costs of obtaining such permits, and difficulties in opening bank accounts, which prevent them from gaining access to the formal economy. Also, in states that are not parties to the Refugee Convention, including Bangladesh, Indonesia, or Thailand, there is no formal right to work for refugees and asylum seekers. Displaced persons in these states are heavily dependent on humanitarian assistance provided by civil society and other organizations, which is often costly and not adequate. This increases the risk of their exploitation and abuse. It is also important to highlight that the access to work is more challenging for those who are not recognized as refugees. In some member states of the European Union, access to the labor market for asylum seekers are granted only after a lapse of time ranging from a few months to 9 months or longer. In other states such as Lithuania and Turkey, asylum seekers are prohibited from entering into the labor market altogether. In addition, some states limit employment opportunities to certain sectors such as agriculture, cleaning, waste management, hospitality, fishery, and car washing, many of which are the informal economy where exploitation is more likely to occur, as I explained earlier. Within a camp setting, many displaced persons still face restrictions on their freedom of movement. And consequently, access to services and assistance is tied to a particular place of residence, making it difficult for them to find employment in many cases. The situation is worse when camps and settlements are far from markets and services, as displaced persons remain dependent on humanitarian assistance to survive. This once again creates a vicious cycle, further increasing the risk of exploitation and abuse. All of these and other factors may inevitably force displaced persons to take on exploitative work, which in its worst form amounts to contemporary forms of slavery, as has been evidenced in all regions of the world. To conclude, it is clear that displaced persons are vulnerable to contemporary forms of slavery as they suddenly experience loss of livelihood. Consequently, many of them are subjected to forced and bonded labor, servitude, forced marriage, child labor, and other slavery-like practices before, during, and after displacement. These instances can be seen in both humanitarian and non-humanitarian context. I have been encouraged by a number of good practices in preventing displaced persons from being victimized in contemporary forms of slavery, but there is an urgent need to step up efforts in this regard, particularly in emergency settings. This is so because contemporary forms of slavery continues to be a blind spot in humanitarian and development responses. This requires a dedicated attention and an increase in the understanding of the nexus between displacement and contemporary forms of slavery by states and humanitarian actors. I would also like to emphasize in particular that anti-slavery strategies should be fully incorporated into all humanitarian protection and responses in the future. The same is true for non-humanitarian settings in regions like Europe and North America. Access to decent work is still limited for displaced populations, with a result that the majority of them have no choice but to work in the informal sector or are regularly exploited by criminal groups in the illegal economy. Therefore, a shift in the mindset of states and other actors is needed in order to treat displaced persons not as a burden, but as rights holders with potential. It is a fact that they equally contribute to the local and national economies, and therefore their rights to work and to just and favorable conditions of work, including access to labor and social protection, must be guaranteed without discrimination. To finish off my talk, I would like to highlight some recommendations I made in my report. For states, they should observe and fulfill work-related obligations arising from relevant human rights instruments, including the 1951 Refugee Convention, the 1954 Stateless Convention, the relevant ILO conventions, as well as the International Covenant on Economic, Social, and Cultural Rights in good faith. They should also strengthen their efforts in providing durable solutions for displaced persons. In this regard, they should ensure that displaced persons are able to contribute to the local and national economies by applying domestic labor laws and by facilitating access to decent work, particularly in the informal economy, without discrimination. To this end, they should facilitate displaced persons access to education, language training, and skills development, as well as accreditation of previous skills and qualifications. In addition, access to justice and remedies for displaced persons who have been victimized in contemporary forms of slavery must be secured. In this regard, states should establish confidential, accessible, child-friendly, and gender-sensitive complaints or referral systems. Further, labor inspections in the informal sector where most displaced persons work should be enhanced with a view to identifying labor exploitation in a timely way and holding perpetrators, including private businesses and employers, accountable. In relation to displaced children, states must provide equal access to free education in language and skills training, regardless of migration status in both humanitarian and non-humanitarian settings. They should also assist their parents so that their children are not forced into the worst forms of child labor, early marriage, and other forms of exploitation. To businesses and employers, I urge them to provide employment opportunities without discrimination, bearing in mind the UN Guiding Principles on business and human rights. In particular, they should facilitate access to employment in the formal sector by recognizing qualifications and experience of displaced persons. Businesses and employers should treat displaced persons on an equal footing with other workers in relation to the just and favorable conditions of work, including fair wages, reasonable working hours, paid leave and holidays, and trade union rights. And for civil society organizations, trade unions, humanitarian actors, as well as academia, I encourage them to undertake further research on the prevalence of contemporary forms of slavery among displaced populations, including data collection, in order to increase understanding and develop appropriate legal and policy responses. There is also scope to enhance communication and collaboration between organizations working with displaced persons and trade unions, as well as other actors involved in labor standards monitoring and bargaining to ensure that the human rights concerns of displaced persons are adequately represented. In addition, these actors should adapt or strengthen monitoring mechanisms in humanitarian and non-humanitarian settings so that displaced persons can be protected from contemporary forms of slavery. And finally, they should raise awareness among displaced persons and host communities about their human rights and existing reporting mechanisms in case of exploitation and abuse. Well, that concludes my talk. So thank you very much for your attention, and I'll be very happy to answer any question you may have. So I will stop there. Thank you.
Thank you very much, Professor Obokata. That was a very comprehensive explanation, both of the Special Rapporteur Special Procedures function and of your report, which is extensive and nonetheless depressing, considering the displacement of people just continues to worsen in the last decades. Thinking about your focus on the impact of COVID on the issue of human trafficking, modern slavery, and the displacement of persons. Siobhan Mullally last year made a remark that due to COVID, there was a particular increase in the exploitation of women and children on sex cams, that kind of online exploitation. Did you find any particular links between displaced persons and online exploitation of any kind? And is this an issue that will take a long time post-COVID to untangle, do you think?
Well, I think that's a good question. That depends on whether or not these displaced children have access to the internet and so on. In many camp settings that they don't, so I doubt that they have been exploited online or anything like that. But for others, school closure certainly means that they do not have to go to school. So what happens then? They spend more time online, and so that has increased. And I'm sure that happens in some of the displaced populations. But even more pressing is that because of school closures, many of the children, including those displaced children, have been forced to work to survive, because particularly for displaced parents, many of them do not have access to work. So that means they send their kids to work, or or ask their young daughters to marry. So in return for economic benefits, which is disturbing, but that's reality that I have seen in some parts like Asia and Africa, and sometimes Latin America also.
Thank you very much for that. I can see a number of questions have come in. I do have another question myself, but I'll leave that and see if there's space. Rory, are you going to read out the questions, or would you like me to?
I'll read them out, Danielle. So we have a few different questions in the Q&A box and in the chat box. We have, I may alternate between the Q&A and the chat, so that a few different people can get their questions answered. But I'll start with some questions from Saul Greenberg. What are the advantages of individuals proceeding through the charter system rather than the treaty-based system? And how does the Human Rights Council special procedures make sure that the system and specific rights of complaint are made known to those people in the world who are most deprived and most in need of help and may not have the luxury of time to wait for a process to take its course?
Right. Okay. Well, thank you. I mean, so obviously there's lots of differences between the charter-based and the treaty-based mechanisms. And one of the benefit, as I see, is that we can we can communicate with victims relatively easier, because we receive allegations of human rights violations, and when we do, we can talk to the government immediately. We do also have an urgent procedures system in place where we, if it's an urgent case, we contact the government straight away, and there's a person 24-hour on call to receive and analyze these urgent matters, and then we send that urgent communications request to the government and other entities such as companies. So I think one of the benefits we have is that we can kind of take action slightly faster than treaty bodies. Oftentimes, it depends on the information received from governments and so on, and they analyze, and that takes about at least a year or two. Whereas in our case, we take much less than that, and talk to victims, governments, and other stakeholders. And we also constantly reach out to victims, other stakeholders on a regular basis in different forums. So that way, we can kind of again, facilitate constructive and meaningful dialogues with all stakeholders, whereas treaty bodies, their activities are constrained by their own terms in a treaty themselves. So it's not like they issue press statement straight away, whereas we can do that. We can start publicizing all these allegations and violations widely for publicity and transparency. And I think that's because we are not governed by a particular legal instrument. Okay, we are governed by our human rights resolutions, but my mandate is slightly open-ended. So contemporary forms of slavery, there's no actual definition of what they mean. So that is an advantage in itself, because I do get to explore different sides of things, not just traditional slavery, but aggravated forms of forced labor, servitude, servile marriage, and so on. And as the time progresses, there may be different forms of exploitation and abuse. But what I do make sure is that there are overlaps with my mandate and others, such as Shibo Mulali's human trafficking. So I do not deal with human trafficking because that's her domain. And we also have a special rapporteur on sexual exploitation of children. So I do talk about sexual exploitation of adults, women, and men, but not that of children. So that is a mandate for my colleague Mama Fatima from Gambia. So we do kind of coordinate that way. I wonder if that answered the question. Are there any follow-up questions to that?
Well, I'll see if any more questions come in, but I have some more questions as well. So sure. A couple from the chat box from Hannah Brooks. And so Hannah has two questions. First of all, on slavery and imprisonment, how does international human rights classify or justify slavery as a punishment for a crime? Why is this separated? Is there specific histories there, or is this just accepted in most nations?
I think go on. Sorry. And
no, if you
should
want to, go.
I answer that first? Well, I think that's an important question. Now, there's a distinction between slavery, forced labor, and servitude. Slavery being the most severe form. We are talking about powers attached to the right of ownership. So that's the most severe. So, and then after that, we have servitude, which is a lesser form of slavery. And after that, we have forced labor, which is, again, the lesser form of servitude. So there is that spectrum. And when you, I presume you mean like prison labor, and after someone is convicted, if that's what you mean, then I think that is certainly is exempt. I mean, it's the forced labor, but that's falls under the exception. So again, if those inmates and convicted persons are required to undertake certain jobs, and I think that is allowed under international human rights law, but that does not mean that we can't ignore their human rights. So I've seen instances last year, for example, inmates in the United States, Hong Kong, and so on, being forced actually to make medical masks, PPE, against their will, and very long hours. I mean, that to me is clear-cut case of forced labor, at least. I wouldn't call that as a necessary slavery, depending on the degree of ownership. But I mean, all of the inmates are, in a sense, under the control of the state anyway. But that doesn't mean that they are in slavery. So no, I think so. So there's a fine distinction. The prison labor itself is permitted under international human rights law, but it all depends on the circumstance. If they are, really, forced to work against their will, and to do this and that, that raises an issue, as well as, for example, the wages. Again, wages are quite low in that kind of settings, but if they are not getting paid at all, for example, that raises an issue under at least forced labor.
Thank you. Thank you. So I'll just take a question then from the Q&A. From Brenna O'Neill, in terms of access to justice for these vulnerable groups, you mentioned that mechanisms should be child-friendly. Could you expand on this? Children in the UK have special procedures in place for them already, and I would be interested to know how these could be extended.
Absolutely. I mean, if you're talking about, there must be like a domestic and international, particularly for international victims, for example, someone who've been trafficked. Let's say it's quite common in this country where young people, children from Vietnam are being trafficked from Vietnam into this country to, for example, produce cannabis in cannabis farm. I mean, that's quite common in this country and Ireland. And for those foreign nationals, one of the difficulties, first of all, is the age assessment. And some children may look younger, much older, and depending on that decision, then if someone is being treated as an adult, and that decreases the chance of protection, because if you're a child under the Children Act and everything, it doesn't matter where you come from. All children should receive protection no matter what from the local community. I mean, that's a legal obligation on local authorities and so on. But so there is that. So if once someone is known, you don't look like a child, and therefore you must be adult, and that actually make them more vulnerable, I think. And also the tailored kind of the language is another issue, and guardian is another issue, for children. And I think under the Modern Slavery Act, that for children, a guardian is to be appointed, and that person must actually know the particular vulnerability surrounding children because of their age, and being forced, to come to a foreign country, language difficulty, and the maturity and so on. All of that must be. So I think the first of all key is to extend protection to all children, regardless of their situation and status. I mean, that's given, but assign someone who is very trained in dealing with children in that terms, and then making that accessible, I think is the key.
Thank you, Tom. So we have another question here. Fiona McGregor, thank you so very much for your very interesting presentation. You highlighted how structural factors play a significant role in exposing people to slavery risks, particularly in camp settings. The states be held responsible under international law for actively enabling slavery or failure to protect, i.e. if displaced people are held in camps, deliberately denied right to work and freedom of movement, and also not provided with adequate security to protect them from crime or access to justice. How culpable is the state and how can that be addressed under international law?
Sorry, let me just, so this is the last question. Let me read it. Sorry, Roy, your kind of sounded slightly, help this one. Of course, I mean, the slavery, states should be held liable for actively or enabling businesses and employers to exploit them in that manner. It is, I mean, as you might know, under international law, prohibition against slavery is one of the highest norms. It's the jus cogens norms, and also part of customary international law. So it really does not matter if a particular country has a legislation prohibiting slavery or not. They should still be held liable one way or another. And in the camp setting is also, camp setting is particularly difficult. I mean, it all depends on who's controlling that particular camp. If you're talking about areas where there's no functioning government, who should be held liable if they are being exploited? And I think that raises an important issue. And if they're being run by UN agencies and peacekeeping missions, surely, I mean, they should also make sure that these things do not happen. But that's a slightly separate issue, I think, from the state responsibility. I think, and the freedom movement is also important. So as I said in my talk, that still seems to be the case, and that increases the vulnerability if they are stuck in one place and if there's no security in the informal settlements and camps. And that means they are easily be targeted by terrorists and organized criminal groups for further exploitation. And I've seen some examples of that in different regions of the world, and that needs to be addressed. And again, states are first and foremost under primary obligation to address those. But again, that's a collective responsibility. So I also think that UN agencies, particularly, who's been sent as part of the peacekeeping mission to ensure that doesn't happen in cooperation with other humanitarian actors, I think. But that certainly is a complex situation, I think.
Thank you. We have another question from Hannah Brooks. My second question, what do we hope to be in place to address second and third and going further generations of displaced persons? How far reaching is this?
That's just, she's talking about the impact of slavery on the third and the further generations. Is that her question? Is it?
I think it's about, you have the first generation displaced persons, but what happens with the second generation? So the children of the first generation of displaced persons and their children.
Yes, I mean, I think that's also important. Depending on the countries, I think in certain countries, I mean, if they are second and third generation, if they're actually born in that particular country, then that should come with, for example, nationality, rights and entitlements. But in others, like as I said, certain countries do not recognize refugees, and those people are stuck in limbo. So they do not even have a nationality, they remain stateless, they do not have an access to education and training and so on. And that basically means they don't have access to decent work, and that still leave them more, at higher risk of being exploited one way or another. So it depends on the situations. I always recommend all states ratify the Refugee Convention and provide equal, if you ratify that instrument, I mean, it's a legal obligation to provide work-related rights to all refugees, in a similar way as their own nationals. And I think that's a starting point. But then there are also other issues such as asylum seekers who do not actually have any status in the majority of the countries. I mean, they are also stuck in limbo. And because the asylum process can take ages and ages and ages in certain countries, even in this country, it may take a year or longer. If that's the case, if they don't have access to employment, what happens? And they are desperate, and that means they go to criminals who would exploit these vulnerable people in criminal activities and so on. And you see that in this country and elsewhere. And I think also that needs to happen. So I think in a long durable solution also means that provide sufficient protection to the second and third and other future generations of the displaced populations. And I think that's an obligation, not just under the refugee law, but under the general human rights law. In international covenants and both covenants, I mean, that have been ratified. So under those covenants and other rights, such as the Convention on the Rights of the Child, and so on, states are one way or another obliged to do so. So it actually doesn't matter if particular states are parties to the Refugee Convention in that regard.
Thank you, Tom. And going back to some of Saul Greenberg's questions, how often have you seen global North countries being investigated as part of special procedures in relation to how they deal with refugees and asylum seekers and the risks of exploitation and these procedures being completed?
Sorry, let me just
Very last question and answer.
Yeah, sorry, how often have you seen global North countries being investigated as part of special procedures with regard to refugees? That's a good question. I'm not too certain. So in my work, then I did, I was able to look at, for example, North America, Europe, including UK, and other wealthy countries like Japan, and see how they are kind of treating refugees. And there are some good practice, no doubt, refugees being able to work and legally in many countries, and I think that's great. But at the same time, there are other countries, even in UK, for example. I think, as far as I understand it, asylum seekers cannot work until after 12 months in this country. In Ireland, I don't think the asylum seekers are allowed to work at all. So I could be wrong. So there are that type of restrictions, which I think is plainly wrong. My message is quite clear. They equally contribute to the local and national economies, just like their own nationals. So give them rights, give them decent, access to decent work, and at the end of the day, they can pay tax, and that can be used to provide social and economic assistance to not just refugees, but to the general population. So I mean, I don't understand, from my point of view, why this is not happening, and this should happen. They should be regarded as an important members of society, and so that needs to happen. But again, that's not just about states doing, but also the communities, which tend to kind of discriminate these populations. So the change in the mindset of states as well as others, like society, including media and general public, I think that's necessary, and they still have some way to go in changing that, I think.
Thank you, Tom. And Paul had an earlier question as well. Are you seeing real positive changes to issues of displacement and modern slavery, including child marriage, of people, including children across the world, following implementation of special procedures? And if so, can you identify them?
Yeah, sorry, I didn't quite get that. Is that the question? Sorry.
That was a question. It was, we go back to the top, there were 5 questions. That was the last question. Are you seeing real positive changes to issues of displacement and modern slavery, including child marriage of people?
Sorry about that. I just read that quickly. By the way, I can stay a little longer if so that's, it's not like I have to finish at 12 or anything. So I'm happy to answer questions as they come along. Are you seeing real positive changes to issues in displacement and modern slavery? Well, I mean, again, I've seen some good examples, and particularly the role of civil society and trade unions have been particularly important, I think, especially in the context of COVID-19 pandemic. They have been at the forefront of, again, trying to protect the rights of all workers, including the rights of refugees and displaced persons. And in terms of child marriage, it's a slightly difficult issue because it's by law, I mean, the most countries actually prohibit child marriage, but it still happens one way or another because it's a kind of a cultural tradition in certain societies. And then once again, it is difficult to enforce that kind of thing, particularly under the situation of emergencies because the states have a more important pressing issues to deal with. So some of these issues, unfortunately, something like modern slavery are often forgotten in the emergency context. And I think that's slightly unfortunate. That's why I would urge all relevant actors to take that into consideration, raise awareness and increase the understanding is important.
Thank you. And then there was another question in the chat box from Colette McAllister. Thank you very much, Professor. I was wondering, could you remind us briefly of the UN human rights instruments that should be applied in good faith by states as part of your proposed recommendations? I think you mentioned one other than the following: the 1951 Refugee Convention, the 1954 Stateless Convention, and ICESCR. Thank you. And I suppose I'll just add a bit, and maybe you mentioned it, where does the Migrant Workers Convention also fit in to that?
Absolutely. No, I think that's a very good point. I should have mentioned that. I mean, refugees by definition can be or are, except for internally displaced persons. Yeah, they are migrant workers, and certainly their norms and principles are important. And one of the, I suppose, the catch of that particular convention is the number of ratification is somewhat lower than other instruments, but you're absolutely right, and that instrument is important, and I do urge all, particularly the global north, to ratify that instrument, so in order to give, again, protect the human rights. And I think you're right, but there are others like ILO conventions are equally important, many of which have been ratified universally. Almost universally, like Forced Labor Convention and the worst forms of Child Labor Convention last year has been ratified by all member states, which is a good thing. But yes, there are other important human rights instruments that you mentioned, and I'm sure there are others as well. So thank you for pointing that out.
Thank you, Tom. I think we've got through the vast majority of the questions, maybe not all, but thank you very much for your engagement this morning. It's been really fascinating hearing.
My absolute pleasure, and it's sometimes difficult to understand what we do and so on. So hopefully, if I was able to kind of explain a little bit, that's wonderful, and I'm sure some of you may be interested in the future if you want to go into this path and be a part of the special procedures in the future, like myself. And this is another way of kind of again practicing human rights law, if you will. So thank you, for your attention, and I do very much appreciate you inviting me today and speaking to your students and other perhaps stakeholders among your participants. So, and I'd like to thank you for your time as well. And again, my door is open. So if you would like to discuss any issues relating to it, and if there are any urgent matters that you want to bring to my attention, please do contact me, and I'm very happy to be in touch and correspond with you.
Well, thank you very much. It's been a fascinating session. Thank you, Danielle, for co-chairing as well. And thanks to all of our students and participants for their very engaged questions. Thank you very much, and indeed. I wish you all a good day.
Thank you.
Thank you.
Thanks, everyone. Just a reminder to my Law 821 students, I'll see you in about 30 minutes, 1/2 the hour, for the final bit of our Law 821 class on Foundations of Human Rights. So, thank you very much. Thanks. Oh, Tom's gone. Thanks, Danielle. Tribute to Lady Hale there with the.
I thought it was an appropriate shirt to wear.
Very good. Thank you very much for doing that, Danielle. That was great. Thank you.
Thank you.